In very simple terms, a discretionary trust is a legal agreement between essentially three parties. That's the settlor, the trustee, and the beneficiaries. The settlor is the person who sets up the trust fund, they're the person signing the document, and they are the people that put in the initial settlement sums or assets into the trust. The trustees, which could be a person or a legal entity, for example, a private company, are responsible for managing the trust assets for the benefit of the beneficiaries. The key point about a discretionary trust is that no beneficiary is absolutely entitled to the assets, so the trustees have the absolute discretion to decide when to give them the assets, how much, and at what point. A discretionary trust is a useful planning structure to pass on shares in a business to protect wealth for future generations. One of its key benefits is that it offers a degree of protection from circumstances that might arise in life, such as death, a divorce, or if a beneficiary is in financial difficulties and is made bankrupt. The reason for this is that the assets do not belong to the beneficiaries in their own personal right. They belong to the state, and therefore the beneficiary cannot do as they wish with the assets within the trust. In terms of other key considerations, the tax consequences of transferring assets into a trust must not be forgotten. One key point to consider is whether business property relief is available so that the business assets going into the trust can obtain the benefit of being exempt from UK inheritance tax. Also, in relation to capital gains tax, it might be possible to defer any gain within the assets going into the trust to a future date. In terms of international consideration, it's very important to determine the residence of the settlor, the residence of the trustees, as often that changes the tax position for the trust, and also where the beneficiaries are resident at the time the trust is set up, or where they're likely to be resident in the future. There are certain jurisdictions that do not recognize trusts, or there might be adverse consequences for them being the recipient of a trust fund in the jurisdiction that they're living in which case all these legal and tax implications must be considered before distribution is made to a beneficiary.